Hello, I'm Rick Anthony, and this is Caregiver Assist, the monthly series of programs of, by, and for unpaid family givers, inspired by my own experience as primary caregiver for my late wife, to whom the series is dedicated. Any one of the 53 million unpaid family caregivers in this country will tell you that there are myriad facets to caregiving for a dependent adult. The role of caregiver is usually thrust upon people who are unprepared for the heavy responsibility of securing the well-being of one or more sick or disabled adults. And if the caregiver, perhaps a daughter or son of an older adult, is separated from the dependent person by hundreds or thousands of miles, the challenges are much greater. But regardless of proximity, there's a checklist each family caregiver should review. And near the top of the list should be the legal issues caregivers must address. So today's topic on Caregiver Assist is the very important issue of the legal implications of caregiving. And to help us is elder law attorney Linda Anderson. Linda has over 35 years of experience in elder law. She's a certified elder law attorney as conferred by the National Elder Law Foundation and authorized by the Pennsylvania Supreme Court. She is a highly credentialed attorney. Thank you, Linda, for taking the time to be here. I know you have a busy schedule because I couldn't get through to you.
Well, thank you for the invitation and persevering.
I didn't realize how important it is until retrospectively. I thought back to some of the issues that we had to face when we knew my wife was going to pass. But in our case, thankfully, I guess, we had taken care of most of our estate planning before she became seriously ill. We were fortunate to have the counsel of a financial advisor whom we had known for a long time and a family attorney who had provided services for 4 generations of our family. So he had the continuity.
Yeah.
Nonetheless, there were some issues that we really had to pay attention to and took some time to make a decision. Is our case typical or are most people not as well prepared?
You know, what I would say is we're all aging. And for those that do prepare, they don't appreciate how that pre-planning actually affects the process, and it does have a huge effect. But for those that don't have the benefit of the established relationships and the planning in place, it's going to be more challenging. There's no doubt about it. Mm-hmm. So, you did a good thing by actually pulling your team together before you actually needed it.
And there still were things we hadn't anticipated because we just didn't know.
Yeah.
With the insurance company, the life insurance company, there was one little issue, and it took my getting to my attorney, and my attorney talking to them and explaining that if they continued in this idiotic insistence, that we were probably going to have to go to court. Yeah. It became a matter of principle.
And in the middle of being a caregiver, you're put in the position of having so much administrative work. It's also overwhelming and challenging and feels urgent. Yeah. And so how do you actually sort of unpack it all and get things done that need to be done?
We learned a lesson, and I'm hoping that as a result of this, other people will learn a lesson. When you sit with a client and to help them prepare, particularly a client who is already a caregiver, is there a checklist you go through to either qualify them or get a sense of where they are?
Absolutely. So when you think about having to deal with an elder law matter, it means that somebody is most likely having an acute medical episode or a chronic illness. And so all of a sudden, that change in health status means they need to figure out legal issues, financial issues, and medical issues all at the same time. Yeah. So every time you have to think about seeing a doctor, a lawyer, and a financial advisor on the same day, it's not a good day.
That's a headache.
It's a headache. But the idea is that when we sit down with our family and our caregiver and our client the very first time, there is a checklist. And the idea is that we want to focus on estate planning, care planning, and then asset protection planning. And the reason why we start with estate planning is there's a concept of what's called surrogate decision making. So when somebody has a serious illness, whether it's chronic or acute, the idea is that you really need somebody to stand next to you who's going to be your advocate. That person needs the benefit of a document, a power of attorney. And so there's a financial power of attorney allowing somebody to handle the finances, or there's the medical power of attorney that allows somebody to help make medical decisions. And the idea is that we want to make sure that the person, the client, the one that's vulnerable, is driving his or her own bus. Who they select is reflected in that document, the chain of command, and then the document has to support that person. So if we need to be able to do some not only minor administrative financial issues, but maybe bigger estate planning and asset protection planning goals, that document needs to be able to give them the scope of authority. And the idea of having the care planning next on the list is, once we know who the surrogate decision maker is, we need to understand, where is this client on a concept of the continuum of care? So there may be somebody who is post-stroke. And the question is will they recover and be independent, or will they possibly need some support at personal care? Or is it a really serious issue where they may require skilled nursing? And so this continuum of care, you start with the assessment of where are they now and where are they likely to be. And then the asset protection planning looks at that continuum of care and say, let's make a list of resources, not just assets and the income, but the family members and other friends who may be helping, but also safety nets, Medicare, Medicaid, veterans benefits. So you think about who's going to be helping drive the bus, what is the care need going to be, and then what resources do we pull together to support the family, the client, and the planning.
That's a lot.
It's a lot and that initial meeting, can sometimes feel overwhelming at the beginning, but by the end of it, what I see is that the families are finally, they understand there's somebody who's going to be able to coordinate all of those things and absolutely navigate them through a process. And so the idea is to understand that it may be the first time that you've had to deal with these personal, serious medical issues, but that they are very typical in terms of how the continuum of care may apply to each type of diagnosis, and what kind of support occurs at each level, and how do we actually support the family and the caregiver.
Obviously, you recommend working with a team yourself and a
Absolutely. What I would say is that most of my clients have never had a lawyer before, and many of them may not actually have an accountant or a financial advisor. And for those clients, what they're experiencing for the first time is the idea of allowing somebody to assume that burden of worry. For people that are familiar with working with accountants or financial advisors, the idea of dealing with increased long-term care expenses, and you saved for a rainy day and it's raining, and how do we actually coordinate whatever asset protection work the family, the client wants with the use of money to get good care, you have to pull the team together. There's all kinds of income tax issues looming inside of assets, and there's all kinds of inheritance tax and death taxes, and there's also control issues. And so the idea of actually trying to do it without the team would be a mistake. And I think many times when I'm working with the financial advisor or the accountant, they're so glad to actually have somebody who can speak to the issues that they may understand at a high level, but to just let me, deal with the details of some of those.
But all of what you've just described costs money.
Yes.
And suppose the client or someone who needs what services you're describing can't afford them. Are there other resources available or services available to them?
Absolutely. Now, unfortunately, you can have, a modest estate. Maybe you have a home and a qualified account, and you're not feeling particularly wealthy. At the same time, you could go to Legal Services of Eastern Pennsylvania. They have, I think, 7 or 8 offices, and they do help people with low assets. And there are, like Pennsylvania Health Law Project. There's also national resources that you can use. But those are resources that if you're not at the lower end of the assets, it's the middle class that finds themselves pinched for the very first time. And so what I think is interesting to acknowledge is that at the very beginning, you may not feel like you need the advice or can afford the advice, and hopefully by the end of the conversation you see the value of the advice. And so the idea is that if we're quoting a fee, or any lawyer's quoting a fee, you have to be able to show how the value is going to be achieved, so that somebody feels like it's worth that investment.
Is most of your work then, in your specialty, elder care, preventive or remedial? That is, you come in after everybody's made the wrong decisions, made all the mistakes, and you have to put it back together again.
It's never too early to plan. It's never too late. So I have had everything, and including in between. When I think about the types of clients that are proactive, some of them are perfectly healthy, and they know from seeing perhaps elder law work in action that the powers of attorney that we draft are different. The wills that we draft are different. There are elder law enhancements inside of the documents that we use as tools when you really have a problem. And so those documents, those proactive clients, just get that foundation, hopefully put the papers in a drawer and never need them. But if they do, they're actually in much better shape. For the people that are trying to do things on their own, I've had some families maybe gift or sell a house to a child for $1. Or they have moved, bank accounts into a child's name, thinking that, this is something that they want to accomplish before they go and talk to the attorney. The problem is that under Medicaid, there's a 5-year look back. And so there are ways that those transfers are going to impact the client significantly. And so the idea is to understand, I'd rather have everything on the list and give you options rather than having to undo, a transfer of house. Many people don't realize, and that's a good example, if you gift a child the house and the house is later sold, if the house was purchased for $50,000 and now it's worth $250,000, that child at the settlement table gets a check for $250,000, but they don't get to exclude all the capital gains under the Internal Revenue Code. So you might have actually moved the house out of a parent's name only to give the adult child a huge tax bill. And when you think about inheritance tax, Pennsylvania says, well, if you give the house but you continue to live in it, you're still going to have inheritance tax. So it's much better, much better to say what your goals are straight up and get advice on how to hit the bullseye rather than having to unwind deeds and cure penalties. And
the rules change all the time, right?
Yes. And circumstances change all the time. And so when there is a concern about how to help a parent that may be losing his or her health, you don't actually start with what to do with the assets. You start with the care planning. Because when people are focusing on how to manipulate the assets, they're assuming that every parent's going to be using Medicaid, and that is actually the way to do elder law work. In fact, that's not the approach. You always want to start with the care plan and figure out what resources are you going to need and what safety nets are you going to need, and then how do you apply the level of care that's needed and is going to be needed with the resources, with the safety nets. So it may be possible to get help from Medicaid or Medicare or veterans benefits, but you also are going to have levels of care that may not be supported by those safety nets. And you don't want to neglect that.
How do you, nobody likes to think about this stuff.
Right.
So, and like, I think it's normal to, unless something isn't right in front of you, you're not going to deal with it. You don't want to think about it. But how do you deal with a family, good relationships, to get them to understand that it is possible, conceivable, as bizarre as it may seem, that they might be sued by an aunt, an uncle, a brother, or sister who allege that you stole from your parents, that you, some terrible thing. It's happened. I know it's happened. I know in one case, a friend of mine, his brother took him to court. It cost him hundreds of thousands of dollars. And when it was all over, nobody won.
Right.
Except that he had spent a lot of money. So how do you get people to understand that the worst could happen?
Right. Well, I think when I'm talking to my client and having the client select those surrogate decision makers, part of the process is to make sure there's no undue influence and that the person has capacity. And then my job is to make sure that when that person is in their role, that they're supported. And sometimes the support they need is unexpected support when a family member or a friend, as you're describing, comes in and really undermines the work that that person's doing. So I have a wonderful friend who also is an elder law attorney, and she calls them seagulls. The idea that they flap in, droppings on the person that's doing all the work and then fly off again. And so the idea of actually knowing that that agent under the power of attorney, that caregiver, is not alone. And so my role is to actually, I think, stand between the person and my agent, who I'm, doing the work on behalf of for the client, and actually explain, that first of all, there's confidentiality. Not everybody gets to be on a committee to decide what's going to happen when, and that, our process is one that includes social workers dealing with other medical professionals, and the idea is that we're pretty clear on what is the best care plan for the client. And, when we think about how hard it is to move from one level of care to the other, those transitions aren't always easy or pretty. And maybe, the caregiver is struggling with the right timing of when to put somebody in a facility, or do they really need to be in a facility? But the idea is that they're given information and they're making decisions, and we're trying to help them implement that plan. Now, when people actually try to look to legal devices to be a sword, sometimes we'll find that they'll make a report of need to an area agency on aging, a AAA. And sometimes that anonymous report of need triggers an investigation, and having an elder law attorney who can deal with the AAA and assure them that there's absolutely nothing falling through the cracks here is really helpful. The idea, if somebody files a petition in our orphans court and saying, well, you know what, this agent really needs to be replaced with a guardianship, the idea of actually having the team already working in a pretty established way really goes a long way, I think, to supporting the orphans court judge's decision. And so the idea is that powers of attorney are meant to be given a lot of respect. Even if somebody files a guardianship petition, that person designated that person as an agent, and we're supposed to support them.
You lost me a little bit. What was the AAA? What does AAA?
An area agency on aging. So, and
I thought it was AAA as in AAA.
Right. No. Every county, because there's some federal funding to the states, every state has multiple counties, and in those counties we have area agencies on aging. So if you want to have a wonderful resource, you find your AAA in your county. That's where you get Medicare information, list of providers. They do Medicare counseling. They also have certain roles in terms of the Medicaid process. They also have adult protective services.
In Delaware County, it's
COSA.
COSA.
Yes.
Yeah. But I thought COSA was principally for the indigent under the poverty line.
No, adult protective services is for anybody who is over 60 and may be at risk. And so even if there are resources, if there is a report of need, it goes to our AAA, and then they have certain protocols they have to follow in terms of the investigation and the timeline. Yeah. So when you have these people that may not actually be operating on the same basis as the agent under the power of attorney, sometimes those AAA report of needs are used as swords to try to get their way into a process that they really have no legal standing in. So,
is all of this further complicated when there is distance? I know a woman, she lives in Portland, Oregon. Her mother and father live in Hawaii. He has dementia and is institutionalized. She has Parkinson's disease, and she's still living at home. And this poor woman is in Portland. She's married, children, a career, and so on.
Yeah.
What do you do for someone like that? And I'm sorry, there's another issue. She has a sister who lives in Hawaii. Sounds good so far?
So far.
She's got problems of her own, so she's of no help at all.
No help, okay. So when you think about trying to be a caregiver from a distance, you It is really challenging. It's challenging to be on site.
Yes.
And so really, when you think about the estate planning, care planning, and asset protection planning, the piece that is the most challenging is the care planning. So what I find is that after holidays, major holidays like Thanksgiving or the end of the year holidays, we get phone calls from adult children who have been home for holidays and say, wow, I didn't realize that my parents were so vulnerable, or that there was a change in their health or their mental status. And so the idea is that there are law firms like ours that are members of what's called the Life Care Planning Law Firm Association. And so we have social workers on staff. And there are also other social workers that can be hired through geriatric care management companies, and they serve an important role. These social workers are always able to assess the current level of care, design the care plan, and then figure out who the providers are to provide that care. And so if you have somebody who's in Oregon and they have a phone call that a parent's in an emergency room and has had a catastrophic, event, how can they get immediate support? Well, if you know that there's an issue for an existing diagnosis, you might have a relationship with a geriatric care manager. And so you have them, that many of them are on call 24/7 and are able to sort of react to those situations and give you some time in order to maybe show up for that emergency. But once you've got a chronic illness, those geriatric care managers have a role in terms of check-ins. And again, sometimes it's important to understand that the transition from home to personal care or hospital to home, any of those transitions require some careful coordination, and that's their sweet spot. That's where they really shine.
We were all too familiar with the emergency ward at the hospital over several months because of my wife. Why is it that they always ask whether or not you have power of attorney, living will, and so on? Is it in their best interest to know that?
So there is actually a federal law that requires hospitals to ask, is there an advance directive or a living will? So it's not a requirement for you to actually produce it, but they must ask. My worry is that if you answer yes, that they're presuming that they know the content. And so they do ask whether they have a copy of it, and they don't. And they don't have a copy, right. So they're required under the federal law to ask, do you have a living will, an advance directive? And so they will ask that many, many times as you go in and out. The question is, what's the best practice for you? Knowing that at some point you may actually need to be in an emergency room, or that your primary care physician may need some of these documents too. And so nowadays you can actually have copies of the documents as little electronic digital things, and you can put them on a flash drive. You can have them emailed or sent off to the providers or the hospital. It's not as difficult as it used to be, where you'd have to actually carry paper. Right. But the idea is that who should have these documents for the advance directive and the healthcare more than anybody is the people that are named in your document. So while we might keep a will private, and we might not give a financial power of attorney until it's needed, the living will and the healthcare power of attorney and the HIPAA that we prepare, there's no reason not to distribute as soon as they're done. And make sure everyone gets a copy. I hadn't thought about having it on a flash drive. That's easy enough. What about does the federal law also require that there be evidence of a no resuscitation? So when you're interpreting a living will? Yeah, is that what it is? Yeah, so when you think about... My wife did not want to be resuscitated. So there's a difference between a document that a patient signs as an advance directive versus a medical chart where a doctor prepares an order. So you can have a living will before a crisis happens, and the document's only triggered if you are what's called end-stage medical condition. It used to be called terminal illness, but it means death is imminent, or permanently unconscious. And so you're saying, do you want a feeding tube? Do you want to be on a ventilator? All those choices. Over here, in a medical record, a doctor can talk to somebody who may be terminally ill, aged, or frail and say, if your heart and breathing stop, do you want to be resuscitated? And if the answer is no, then they'll put in the medical record a doctor's order to do not resuscitate. And so you can actually have both of these things inside of your record. Over here, the trigger would be, are you permanently unconscious or end stage? Over here, the question is, has your heart and your breathing stopped? Mm-hmm. So they sort of overlap for that end stage part.
Mm-hmm. Well, I signed the paper as a proxy for my wife.
For the do not resuscitate, yes. Right. So you would have either been an agent if you were in a document, or you would have been a healthcare representative.
Yes.
Yes.
As I was.
Right. And the doctor was talking to you to make that decision, and once the decision's made, the doctor order went in the chart.
Mm-hmm. You said earlier that you do not advise people to go online and to get the necessary forms for power of attorney and some of the other documents we've talked about. It does make it easier. And there are the templates and so on that are available. However, comma.
Right. However, there's a really good analogy that if you were going to have some surgery done, would you ever try to get the instructions by watching YouTube videos? And the answer is no. And when you think about doing the work of estate planning, it's a mistake to think that it's just the templates or the documents. There's actually a lot of things that are nuanced, and it's not just what's in the documents, it's how assets are titled and how you choose to reflect who's in command and who do they have to report to and what is in the scope of authority. And if you don't actually have your preferences in the document, then you do worry about those seagulls. And when I think about the things that have unraveled when I've had to sort of remediate, documents that were gotten on the internet, it sometimes requires a guardianship. The person loses capacity. I can't have a new power of attorney executed by them. The scope of authority was just not appropriate. And all of a sudden we're pushed into a guardianship. Or the will says, I want to make equal gifts to all of my children, but over here, maybe the assets were beneficiary designations where it was just to one child, or maybe it was a joint account with just one child. You have to actually coordinate it. When you think about the things that are most important to you, your care, your spouse, your family, your wealth, it's not the time to think about that most important work and to try to do it yourself by going online. It's not a good approach. It'll cost you money and time at the end.
Sure. What's, if you can share this with us, what's the worst case you've had of family disruption as a result of differences of opinion, quarrels, avarice?
What I would say is that every family has a story. And everybody assumes that every other family is so easy and typical and, no drama. But what I would say is that every family has a story. And when I am told, by my clients what the dynamics are, what the issues are, where are the things that they consider, the family secrets or the things they are embarrassed by, what they need to understand is I've seen it and heard it all before, and there's nothing that they should feel embarrassed or judged by. And when you think about the squabbles, there are families where those children didn't get along when they were 3 and 5.
Oh, yeah.
And now that they're 60 and 58, they're still not getting along. And so those are predictable dynamics. And at the same time, if you follow the straight line of doing the elder law work properly, those things don't actually have any influence on what the goals of the client were. Now, have I had really challenging cases? Yeah, absolutely. I mean, I think one of the worst was a family fighting over the meat in the freezer. And when you think about the meat in the freezer, is it really about the meat?
No.
It's not about the meat.
No, it's not at all.
Okay? And so the idea of actually trying to help that family, my goal for that family is if they got along before I came along, I want them to get
Why
along
don't you
after.
just pull the plug on the freezer?
Right, yeah, or just divvy up the meat. But the idea is that there have been very difficult family meetings, and the bottom line is that we really want the family to be united afterwards if possible.
Linda, this is all scary stuff. How can people learn more about elder law and the things they should know?
So there is a lot of information on the internet. There is NELF, NELF.org, which is the organization that certifies elder law attorneys. So no matter where you are, you can find that. There's NALA, the National Association of Elder Law
And
Attorneys.
there's your website.
There's also my website, which is Anderson
There's
Elder
a lot
Law.
of information on your website.
And we're always adding more to it. So absolutely. And, again, there's a lot of other resources, and we have a resource list on our site.
Thank you so much for being here.
My pleasure.
No, it's been very enlightening and scary. My guest today has been Linda Anderson, who specializes in elder law. Until next time, I'm Rick Anthony. This is Caregiver Assist. Take very good care of yourselves.